right. We're going to get started with the next panel. It's going to be discussing, it's entitled More Than Property, Advancing Animal Status Within the Criminal Justice System. My name is Kathleen Wood. I am a staff attorney with the Animal Legal Defense Fund's Criminal Justice Program, and I'm very excited to introduce our panel. First up, we have my boss, Lora Dunn, who is the director of the Criminal Justice Program at the Animal Legal Defense Fund. She has done a lot of legislative work, been involved with the 2013 strengthening of animal protection laws here in Oregon, as well as in 2015 making animal cruelty crimes an abatable nuisance. She has also written extensive done extensive amicus work on some cases that I'm sure a lot of you are familiar with here in Oregon, establishing crime victim status for animals, including Nix, Fessenden, and Newcomb. And she is an alum of the Lewis and Clark Law School, where she now is an adjunct professor and teaches a Crimes Against Animal course. With the Animal Legal Defense Fund's Criminal Justice Program, she assists prosecutors, law enforcement, veterinarians around the country with animal cruelty cases. Next, we have Jake Kamins, who is the nation's first and only animal cruelty deputy district attorney. So he is for the past 6 years, he's been a fully sworn district attorney with the Benton County DA's office, but he travels throughout the state of Oregon prosecuting animal cruelty crimes. He also provides trainings for other prosecutors, law enforcement, and veterinarians, and has helped with legislative drafting and testimony. Like Lora, he is also an alum of the Lewis and Clark Law School, during which time he clerked with the Clackamas County DA, and after graduation, he worked as a deputy DA here in Multnomah County for 4 years, where he developed a passion for working on animal cruelty cases. And then finally, we have Dr. Melinda Merck, who is a forensic veterinarian and essentially pioneered the entire field of forensic veterinary science. She literally wrote the book on the subject, Veterinary Forensic Investigation of Animal Cruelty. She developed the first veterinary forensics course. She often guest lectures around the country, including here at Lewis and Clark Law School. She has worked with so many different organizations that I don't have the time to list now, but she works locally in Austin and nationally with the APA, the Association of Prosecuting Attorneys, as well as internationally. She was one of the founding chairs of the International Forensics Veterinary Sciences Association. She currently lives in Austin, Texas, where Dr. Merck is the owner of Veterinary Forensics Counseling, which provides expert case consultations throughout the country on animal cruelty crimes. So please join me in welcoming our panel, and first up is Lora Dunn.
Great. Good morning. I'm really honored to be here speaking at this conference, speaking on a panel with these esteemed practitioners. About 10 years ago, I attended my first animal law conference as a student of Lewis and Clark Law School. So just again, I know that Joyce and others have mentioned, but for all you students out there, you are the future of this field. So I'm really glad that you're here and participating in this weekend. I have 20 minutes to cover all of the exciting trends in criminal animal law, which is a big task. I won't be able to cover everything. There's a lot of carnage and a lot of really tough issues and cases that we deal with in this line of work. I'm going to attempt to present a pretty uplifting program for the next 20 minutes. Again, I can't cover everything, and there are so many ways that the law and criminal law does fail animals, but I'm hoping to highlight some of the ways that animals are protected and some of the ways that animals are seen as more than property. So I'm going to do this in kind of two parts. First, how the law treats animals, and again, you've already heard from a number of speakers about animal cruelty statutes in all 50 states. Animal cruelty can be prosecuted as a felony in all 50 states. Again, there are a number of pitfalls in those statutes. Farmed animals, wildlife, animals that are considered pests simply do not have the protections that they deserve. But there are a number of really interesting ways that the law is I would propose, already recognizing animals as more than property, whether certain lawmakers and courts want to acknowledge that or not. And then secondly, I'll be talking about some of the actual approaches by practitioners in criminal casework. So as Kathleen mentioned, I was lucky enough to be part of a bill here in Oregon in 2013 that actually, among many other things, codified the fact that animals are sentient creatures in the law. They are living, feeling beings who suffer. You can see the language there. And this is not just an academic exercise. As Jake and others who do this work in Oregon can tell you, that having this kind of statute on the books is really powerful on a pragmatic level for those prosecutors who are before judges who might not understand the importance of an animal case. Being able to point to a law like this and say, no, actually, the legislature has made a determination that animals do suffer, they do feel pain, and that matters. So we're really hopeful at the Animal Legal Defense Fund that more states will follow suit and pass this kind of legislation. Because again, as other speakers have noted, language like this seems pretty common sense to most of us, and it's really a reflection of where societal values are. So that's one way, again, for those of you who are out there in the field to make a difference, look at legislation like that. I could spend an entire day on some of the case highlights throughout the country, and even here in Oregon, but I'll go through pretty quickly. Newcomb was a case that got a lot of attention a couple years ago. The issue was really whether law enforcement that had seized an animal legally from a situation of neglect, whether a warrant was needed to do diagnostic testing, in particular blood testing, on this dog, Juno, who was severely neglected. The court, based on precedent in Oregon and based on the recognition that animals are feeling beings who do suffer, whose medical care needs to be addressed in a timely manner, ultimately determined that doing that kind of diagnostic testing subsequent to a legal seizure of that dog, that was not a search, that a defendant did not have a protected privacy interest in that dog as to that blood test, again, because the court went back to the fact that animals are living beings. This dog, Juno, was not like any other property that could simply be put away, so to speak, during the pending case. Another big victory here in Oregon, and I know that Jake was involved in this in various ways, State versus Nix, as others have mentioned, found that animals are victims of crimes in certain circumstances. I won't go into a lot of the complexities legally, but the context of this case was sentencing in an animal cruelty case. The question before the court was squarely before the court was whether an animal is a victim of a crime for purposes of Oregon's anti-merger statute. As my law students know at Lewis and Clark, we could talk about that statute all day. But the takeaway was that for the court, animals are not just like any other property. They might be categorized as property under the law, but the legislature in Oregon has made these determinations that animals matter under the Cruelty Code. And therefore, animals could and were considered victims in that statute. And my colleague, Matthew Lehman, will be talking a bit more about other advancements in the law, at least partially because of cases like this. Pre-conviction forfeiture is one of my favorite topics, a little bit legally dense, and it's procedural in large part, but really makes an impact for individual animal victims. So this is a legal mechanism by which property ownership is transferred from a defendant in a criminal case who has been charged with animal cruelty to a state entity that has seized the animal or animals, or some kind of third party. I have Oregon up here as an example. And essentially, courts who weigh in on the constitutionality of these statutes have found that they are constitutional, that they are important because ultimately it goes to the animal's well-being. When animals are seized as part of animal cruelty cases, again, as our other panelists up here know well, they are often held as evidence for the duration of a criminal case. That can be months, that can be years, especially for animals who have already been through a lot, from a puppy mill situation, from another situation of less than optimal conditions. Keeping those animals, even at one of the best local humane societies, can really be detrimental to those animals' physical and emotional well-being. So what this legal mechanism allows for is for those animals to be, their ownership interest to be transferred, and then they could perhaps be adopted out to better homes, to better situations. This is an example of a case that the Animal Legal Defense Fund was involved with. Animal Rescue Corps did the on-the-ground work, and kudos to them for everything that they did. This was a Tennessee case, a hoarding case in large part involving a number of different animal victims, both those who would be considered companion animal and farmed animal victims, cats, dogs, chickens, goats, geese, sheep, horses, alpacas, chinchillas, ferrets, rabbits, and one duck. This was a case in which pre-conviction forfeiture was really helpful, and that case is continuing on appeal, so we'll see how courts take up that issue. This is another case out of Oregon from a few years ago. The Oregon Humane Society was involved in rescuing dogs like Baxter, pictured here, from a puppy mill situation. This was one of Jake Kamins' cases as well. And I show these pictures again to point out that a procedural legal mechanism can make an impact on an individual animal's life. So here is Baxter pretty immediately after being seized on the top from that cruel situation, and then afterward living the good life, I think at the beach in the picture on the right. Sorry, that's a little bit fuzzy. But again, one of the ways that something that is pretty legally technical can make a big difference. We are seeing, at least in the Animal Legal Defense Fund, we are seeing pre-conviction forfeiture come under fire by defendants who are especially litigious, who want their animals back, who want to keep their animals. I'm happy to say that in most cases, these statutes are holding up, but we're continuing to fight on a number of cases in a number of states. Just this past month, Mississippi's pre-conviction forfeiture statute came up. So, emergency situations, as I think most of you are probably aware, in many states now, and thanks to our clerk Madison for helping with the list. This is not comprehensive by any means. In a number of states, courts are actually recognizing that animals can and should be seized by law enforcement in emergency situations without requiring law enforcement to get a warrant. In a recent Oregon case, a horse who was suffering tremendously near the brink of death, according to the officer, that horse would have died had the officer waited to get a warrant. So again, these are situations that it's not just an academic exercise. It's not just legally interesting. This impacts real cases and real animals. So speaking of emergency situations, very unfortunately, we see in our work every year countless situations of animals being left in hot cars or vehicles where they are left even for 10 minutes at a time, and there are negative impacts for the animals. So again, we see these in the news all the time. These are preventable in large part. Usually folks who simply don't understand that the temperature can rise in these vehicles very quickly. So what's being done about them? Hot cars laws, as we call them, are being passed and have been passed in a number of states. Some of these laws are what we call Good Samaritan laws that empower citizens to enter a vehicle to actually take animals. Before any of you do that, and I should say I am only licensed in Oregon and none of this is legal advice, certain steps have to be taken first. Citizens, depending on the state, have to attempt to call law enforcement first, call 911 when they see a situation that puts an animal in danger. They have to take only reasonable measures in trying to get the animal out of that vehicle. So again, don't leave me on the hook if any of you engage in this activity. Check your state's laws, always important. And then other states also specifically criminalize leaving an animal in a vehicle. General animal neglect laws can get at these situations, but again, going to legislation reflecting societal values, these laws are really important and send a message to law enforcement that these cases and these situations matter. A plug for our rankings report that we put out every year. Kathleen does tremendous work on this project along with the rest of our team. We are seeing some really encouraging trends nationwide. I don't have time to go into all of them, but everything from animals being included in domestic violence protection orders, those protection orders that would cover, for example, getting children and other people out of a situation, keeping them safe from a potential violent offender, also includes animals in a number of states now. Hot cars laws, as I mentioned, states are recognizing the importance of mental health evaluations and treatment for animal cruelty offenders, which we at the Animal Legal Defense Fund see as a really significant part of this work, because for everyone doing this kind of work, making sure that these kind of situations do not happen again to animals is really crucial to this work. Veterinarians, which Dr. Merck might touch on as well, veterinarians are required by law in many states to actually report animal cruelty. And that's, of course, important on a pragmatic level because veterinarians are sometimes the only folks who actually see an animal who is being cruelly treated outside of their home. They might be the only witnesses to that kind of abuse and neglect. So having them report that to law enforcement is really important to abating those situations. So, some really exciting and new approaches to criminal casework. We are seeing in more and more states in the last 5-10 years specific animal cruelty units in prosecutors' offices. So these are not only folks who have perhaps carved out animal cruelty casework in their docket, have made themselves known in their offices as being the animal cruelty person, but have actually gone above and beyond in starting units specific to this casework. And we're seeing these pop up nationwide, California to Florida to Texas to New York. As Representative Urban noted just a few moments ago, courtroom animal advocate programs are a really unique way of approaching these cases and these issues. So, of course, as most of you know, traditionally, in an animal cruelty case, there are only two parties to a case. There's the prosecutor, whose job is really to represent the interests of society as a whole or the interests of justice, not necessarily the victims of a particular crime, and not necessarily a particular individual. The defendant is traditionally the other party to the case. Again, not news to most of you. What laws like Desmond's Law do in Connecticut, the first one passed in Connecticut, what these laws do is create a sort of third table in the courtroom for someone to represent the interests of animals in particular. This raises, of course, a whole host of questions. Essentially, this is an additional resource for making sure that every possible piece of evidence in an animal cruelty case comes forward. And again, on both kind of a philosophical level and pragmatic level, there is someone speaking directly for the animal victims in these cases on everything from pretrial motions to issues that come up at trial to sentencing. This could have some real, is already having some real impacts in Connecticut, where the first law was passed, and where folks like Professor Jessica Rubin, who was very heavily involved in this, is doing some great work. We have been proud at the Animal Legal Defense Fund to be involved in actually implementing Desmond's Law and other CAPS laws. We're hoping to do the same in the future. My colleague David Rosengard was involved in a training in Connecticut. Again, a really important piece. Questions are raised, of course, about who will these advocates be, what will their training be. Rest assured, we have a model law on our website, aldf.org, that anticipates some of these questions and issues. We're really hopeful that we will see more of these laws passed in other states. So trainings, and again, there are many who have come before, certainly my work and the work of my department, to lay the groundwork for even approaching prosecutors. There are folks who worked for years to emphasize to prosecutors that an animal cruelty case should even be taken up, that they should take time in their day with their very busy case docket involving human victims, that they should care about animal cases. The criminal justice program has focused on a number of trainings in recent years, those for prosecutors, for law enforcement, for veterinarians, and others who are on the ground doing this work. I'm really proud to say that within the past year, we formalized a partnership with a judicial group, the National Council of Juvenile and Family Court Judges. I'm very proud that and happy that some of those folks are here today with us at our conference. We had the first ever formal judicial convening on these issues earlier this year in January, and had some really interesting and exciting conversations with a number of judges from throughout the country who really get these issues and who we are already seeing are going out into their communities, speaking about the importance of animal cruelty. And we're finding that just reaching these, as I say up there, key decision makers will only bring a bigger impact to this work. So I'm short on time, but I wanted to highlight, thank you to NCJ, FCJ, they passed a resolution specific to animal cruelty and the importance of recognizing these cases and these issues. We published together a bench book of sorts for judges specific to animal cruelty this year. I have a few copies up here if anyone wants to look after the talk. But we touch on a number of issues, especially those that impact, again, family court and juvenile cases. So where do we go from here? There's a lot of work to be done, so I'm glad that all of you are in this room. Again, legislative recognition of animals mattering on a number of levels. I'm hopeful that we will see that trend continue. There's a lot of work to be done, and that is being done in the realm of farmed animal protection. As Joyce and others noted, farmed animals are largely exempt from a lot of cruelty laws in a number of different ways. And I can tell you that the Animal Legal Defense Fund and others are working really hard to change that. Training really important stakeholders, like judges. I'm hoping to see more of that in the future, and more of these courtroom animal advocate programs, that legislation will be passed and actually implemented in the future. That is my cat Panther posing for Halloween. I can't do a presentation without sneaking him in, or maybe he snuck this slide in, I'm not sure. But thank you for your time and for all the work that you're doing for animals.
Good morning. Thank you to the Animal Law Conference for bringing me in to speak today. I really appreciate the opportunity to talk to all the stakeholders, policymakers, and dreamers of the animal law world to let you guys know what we've been doing here in Oregon with the animal cruelty deputy district attorney position. I have a lot of information to get through in 20 minutes, so here we go. I want to give you all a brief overview of the state of animal cruelty laws in the state of Oregon. We consistently get ranked second in the Animal Legal Defense Fund's rankings of animal protection laws. Not sure what we have to do to break through. We do have a bit of a inferiority complex here in Oregon about that state to the south. Won't go any further into that. But we have been doing great things. So just to give you a quick overview of the laws, then I'll talk about my position, then I will talk about things that I've observed in that position, areas of possible improvement, and ways we do things really well here in Oregon. In Oregon, animal cruelty generally breaks down into two broad categories. I find that this is true in other states as well. Animal neglect, where somebody fails to provide what's called minimum care to an animal in their custody or control, and animal abuse, where a person unlawfully and intentionally, knowingly, or recklessly causes serious physical injury or death to an animal. These are all very broad definitions, and just like Lora, I'm not any of your lawyers, so please do not take this as legal advice. Offenses in the animal cruelty world in Oregon range anywhere from a Class C misdemeanor with a maximum of 30 days in jail and a fine to a Class C felony with a theoretical maximum of 5 years in prison, but a true possible theoretical actual sentence of probation. In Oregon, state criminal law is enforced by district attorneys. There are 36 throughout the state, and they are responsible for representing the state in criminal cases. Now, there's a brief overview of the timeline of Oregon animal cruelty laws. Lora mentioned Senate Bill 6. That really kind of kicked off a new era in Oregon's animal cruelty protections. It made animal neglect a possible felony for the first time. It increased significantly the possible penalties for animal abuse and animal neglect, created a registration scheme for animal rescue entities, which has since been further amended to make sure that rescue entities are actually doing what it says in the name, rescuing animals, and establish these legislative findings, which Lora talked about, which I'll talk about a little bit more in a minute. My position, I think kind of coincidentally and kind of by design, was established the month after Senate Bill 6 went into effect. I did bring the first animal neglect felony in the state to trial about a year later, got a conviction and 3 years prison behind it. Then, several years later, the Oregon State Police officially commissioned the Oregon Humane Society agents as police officers with statewide authority to investigate and arrest for animal cruelty offenses. And then, as Lora talked about, we had this dogs in hot cars bill go into effect. Was that gesundheit or was that a bark? I couldn't tell. All right, it kind of sounds like a sneeze. In 2017. And we've done more work in the interim and since then, but those are just some highlights. Now, about me, my favorite subject. I was a prosecutor in the Multnomah County District Attorney's Office, having gone to Lewis and Clark Law School, one of the foremost animal law education facilities in the country, having done nearly none of the things that you would have expected for a Lewis and Clark Law School student. I was not a member of the Animal Law Review. I was not a member of Student Animal Legal Defense Fund. I did not take any animal law classes. I was focused solely on getting in the courtroom and talking as opposed to writing for my legal job. And in so doing, I became a prosecutor because that's what we do. We go to court and we argue our positions. Sometimes we're called upon to write, but that usually means copying what some other smarter lawyer has done before us and providing it to the judge. So, working at the DA's office, I found the possibility to specialize in this field intriguing. I had done, through my sort of general portfolio of cases, some animal cruelty work, and as a result, really found that these were very important cases, very complex cases, and cases that, when they came up for us line prosecutors, sort of threw us for a loop. You can get any deputy district attorney to try a DUII case or a domestic violence case with their eyes closed and one hand tied behind their back. They know all the things that are going to come up. They know all the legal arguments, all the pitfalls. And then an animal cruelty case comes along, and we're just stumbling blind. So I jumped at the opportunity to do this. As you may or may not know, the funding for the position is provided by the Animal Legal Defense Fund. It's housed at the Benton County District Attorney's Office. Is currently funded, I'm happy to say, through 2021. I have 3 or 4 essential practice areas in my job, the biggest one being actual casework, going out and signing on as a special prosecutor county to county to actually prosecute these cases in lieu of their local deputy district attorneys. I have done that in 21 of 36 counties. There are some counties in Oregon where animals outnumber people, so I haven't gotten to those. And also, my work tends to take me to the counties with less financial resources, so I have not done a ton of work in the metro area here as animal cruelty deputy DA. I also assist law enforcement, prosecutors, judges, other lawyers in understanding the ins and outs of these cases, because as much as I'd like to, I can't be everywhere all the time and prosecute every single animal cruelty case. So when I'm not there, I want to make sure that my words are ringing in the ears of the people investigating and prosecuting these cases. I also generally serve as a contact for the media if they have questions, generally speaking, about what animal cruelty laws mean, what case law means, and what is happening. Obviously, due to the nature of my position, I can't talk a whole lot about my ongoing casework in the media, but I'm happy to opine about Court of Appeals rulings, Supreme Court rulings, and new laws, things like that. So, I broke down these next couple of topics into a few different sections. I want to talk first about what I've seen in terms of animal cruelty investigations. There are a lot of issues that come up in animal cruelty investigations repeatedly. We have witness reluctance. This is typically when you have either a neighbor or a family member or just a community member who sees animal cruelty. They want to report it, they want it to be fixed, but they don't want to show up in court. They don't want to confront the person in court. And unfortunately or fortunately, we have in this country the confrontation clause, which means if you're going to prosecute somebody criminally, if you're going to send them to jail potentially, you have to put the witnesses on the stand for them to be able to cross-examine them. So we have a lot of work to do in terms of making sure that people understand that you can't just make an accusation and then back away from it and expect anything to happen. Those animals are going to keep getting abused or neglected, and nothing is going to change. There's also what I commonly refer to as the training gap. This works on both animal services officers and on patrol officers who enforce the laws generally. So the patrol officers tend to get training on interviewing suspects and witnesses and defensive maneuvers, and they get certainly training on their constitutional obligations. They don't get a lot of training specific to animal cruelty investigations. So when I have a patrol officer investigate an animal cruelty case, I am often disappointed but not surprised that they have chosen, instead of having a post-mortem exam done on a dead animal body, to release that body back to the owner when it's then buried and all the evidentiary value is lost. I've had officers that have just simply left a dead animal where they found it and haven't done anything with it. And then I have to deal with that going forward. And I tell these officers, the judge is going to hold us to the same burden of proof that they hold the prosecutor to in a murder case. And can you imagine a murder case where you tell the judge, we just left the body where we found it? We didn't do any testing. We didn't, went to the crematory. I don't think that's a thing that happens. So I have to train those officers to do that. The flip side is animal services officers, as trained and thorough as they are in the majority of their job, which is code compliance, finding stray animals, reuniting them with their owners, dealing with noise complaints, dealing with, complaints about unlicensed dogs. They don't have the kind of law enforcement training which would allow them to build the most solid animal cruelty criminal case. So they may not have that ability to question a witness effectively. They may not have the ability to deal with chain of custody issues as well as they should. So I have to try to bring that gap into as small as it can go. There's also some local codes that will overlap with our state law. So we do have state animal cruelty laws that I talked about. There are also county and city ordinances that allow animal services officers and law enforcement officers to charge people with the same offenses, but with different levels of penalty. So they might be violation level offenses under the city or county code. And law enforcement officers will often take that route. The problem there is that if you charge somebody with a violation level offense as opposed to a crime, you may not be able to take their animal away from them. You may not be able to prevent them from possessing more animals. You cannot get the person put on probation for a violation level offense. So they pay a fine and they go along and live their life. Resources for both law enforcement and animal services in relation to animal cases is low, and this is a problem across the board in law enforcement. Resources are a problem, but when you have live evidence, when you have evidence that needs to be specially stored in particular conditions, and when you have issues of what are we going to do with that evidence beyond just seizing it, we have to put this living sentient being somewhere during the pendency of this case, that can often run into just budgetary reality. I told you about dogs and other bodies not being processed. There's also the issue of disappearing evidence. Obviously, people do not want to be charged with animal cruelty, so they occasionally, I've seen networks of people who are committed to keeping animals that are alleged to have been neglected out of hands of law enforcement, so they will move animals from one place to the other. Obviously, this is an issue that spans the entire criminal justice system, but for some reason there is a willingness of some communities to assist even when there are abused or neglected animals. And then there's the issue of forensic sciences. So if you have a case with a human victim that has DNA, that has fingerprints that need analyzing, you need blood to be checked over, even on the most basic level of somebody coming in driving a car drunk, they have police resources to test all of that forensic evidence. In our animal cases, I'm not aware of, aside from the federal animal cruelty investigation forensic team, which is actually here in Oregon, any ability to do any of that testing by a police agency. So law enforcement is essentially required to figure out what to do on the ground running. So they'll take their evidence to a veterinarian and say, what can you tell me about this evidence forensically? And that veterinarian may have contracts with a lab. That lab may be in California, boo. It may be in Maine. It may be in Michigan. So they're sending our evidence on these cases all over the country and getting results back. And for their work, for a vet's work, that's fine, because none of their clients are coming back to them and saying, I need to see the chain of custody of my animal's lab results. They're not saying, I need to cross-examine the person who actually did this testing. But for my cases, I do have that confrontation clause issue. So I'm having to go and track down people in California or Maine or Michigan to come testify. So what do we do well? What can we do better? Well, we try to raise public awareness of these evidentiary issues so that people know it's not enough to just call the police anonymously and make a report of animal cruelty. We can increase and improve training, and one of the main things that I've been doing for the past 6 years is training everybody who will listen on best practices for investigating animal cruelty offenses. We can fund positions and fund training for animal services officers. Animal services agencies are dying to fill these positions. They are empty and they are just, sitting open, waiting for any law-minded animal person to come and take them. They are good, it's good work, and you can work on some of the most important cases in this area. We work with the existing forensic labs to improve their chain of custody procedures, and we ensure that they know when they're dealing with a criminal referral. So this is a crime. You need to handle this evidence in a way that comports with the law and that allows us to introduce it at trial. And of course, as Lora mentioned, we can go through the pretrial forfeiture procedure. That's something that judges, defense attorneys, and prosecutors are not as familiar with as they should be. I've trained multiple prosecutors on that procedure, and we've had a lot of great successes there. When it actually gets to prosecution, we, Oregon prosecutors, work hard to make sure that these cases are fully prosecuted, but animal cruelty is an offense that can be hidden from public view in a lot of ways, and it's tough to get evidence that you need to fully prosecute it. So as I mentioned, prosecutors don't have as much experience with these cases as they should. They're also very busy. This law is complicated and it updates regularly, and judges and the defense bar are similarly in the dark about these cases just because they don't see them very often come across their desk. So what we can do and what I have done is create training materials for prosecutors so that they know what they are dealing with. The Animal Legal Defense Fund has created my position to allow us to get around the state on a fairly easy basis and cover these cases a little bit more thoroughly. Also possible to send out updates to prosecutors so that they know what the changes in the law are. This is impossible to read on this slide, but is a quick training guide that I created for Oregon prosecutors that I handed out at their annual conference a few months ago. Now, the last section I want to talk about is in charging and sentencing. There's a lot of things to cover here, and I'm happy to talk a bit about it after we've all given our presentation, and I'm happy to talk with anybody individually as well. These legislative findings are amazing, and not to put too fine a point on it, but I don't know that I've had a trial as animal cruelty deputy district attorney where I have not said animals are sentient beings capable of experiencing pain, stress, and fear, and should be cared for in ways that minimize pain, stress, fear, and suffering since I started. And because those are in the law, that means that is fair game for argument. That means you can stand up in front of a jury and you can say those sentences and defense attorney cannot say boo. The rest of it is all good as well for various reasons that I won't get into because I'm down to my last minute. Oregon does recognize animals as victims. I do have a small part to play in that, but there's too much to get into at this time. We do allow restitution to be provided for the care of the animals all the way through to conviction, if you can convince a judge to do it. Animal cruelty felonies can, if there are enough aggravating factors or if the criminal history is bad enough, lead to serious prison time. And judges don't have the authority to waive a statutory possession ban except in limited circumstances. Now, there are areas of possible improvement. As I said, these cap out at C felonies for reasons that are too complicated to go into now. It's more important that animal cruelty felonies cap out at what are called level 7 crime seriousness felonies, which means that for most criminal defendants, their presumptive sentence, even on the most serious animal cruelty felony, is going to be probation. So animals can't themselves personally get ongoing costs of care. This is an issue that Animal Legal Defense Fund is dealing with in a civil case currently. But the law essentially in the criminal world says once a person is sentenced, those costs stop. So if they have continuing health issues related to abuse or neglect, there's no function in the criminal law to get those costs paid for. Judges, because of the level of felony that these are and the level of misdemeanor that they are, judges do have complete authority over what they want to do in terms of sentencing. There's no room there for mandatory minimum sentencing from the prosecution side. The statutory possession ban is from 5 to 15 years, and violation of it is a Class C misdemeanor. And something that Lora mentioned is mental health treatment. I think we can all probably agree that mental health is self-evidently part of many, if not all, animal cruelty offenses, and yet mental health treatment in the animal cruelty realm is pretty limited, and judges are pretty rare to actually impose something like that, even on a probation sentence. So, thank you for your time, and I'd be happy to answer any questions going forward here today. Thank you.
Let's see if we got this going. So I've been instructed to give you this warning, all right? It's not going to be really bad, but I'm going to show you some cases as I've been asked to speak about suffering in animals. Now, a lot of talk has gone on about sentience and things, so I'm not going to reproduce things. There's certain aspects of it or things we grab in the veterinary world so that we can bring that in court, because we do have judges that don't allow us to refer to the animal as a victim, or we have to articulate the animal's experience. So there's interesting things coming. I just want to make you aware of that have happened. 2012, there's the Cambridge Declaration of Consciousness. Animals have the neurologic substrates for consciousness. It's important. And there's things that we already recognize for years in other aspects of animal welfare. So American Veterinary Medical Association, the shelter medicine guidelines. The guidelines are you do not euthanize an animal in front of another one. Why not? Right? So it's implied that there's an impact, right? So I gotta switch around here. There's the 5 freedoms of animals, and this was established years ago out of the UK from the Farm Animal Council. It's been adapted and accepted on an international scale as a standard for animals, right? So it's been accepted by the different welfare organizations in the United States, but also the World Small Animal Vet Association, the World Organization for Animal Health, all the RSPCAs and all those different countries. And what it goes into, just briefly, is the freedoms of animals. Now, it's been renamed from the World Small Animal Vet Association's Animal Welfare Guidelines, and they call it now the 5 welfare needs. Not the freedoms, this is their needs. So they've restructured it a little bit, but it's freedom from hunger and thirst, freedom from discomfort, freedom from pain, injury, or disease, freedom to express normal behavior, freedom from fear and distress. And this is a big one, right? That means to avoid mental suffering. Anytime you fail to provide for any of these needs or these freedoms, we get suffering of animals. So how do we address this? We have physical and we have emotional suffering of animals, and depending on the individual statutes and how that's going to be applied, it can be short-term, it can be chronic, it can be intermittent, but we have to consider the emotional aspect of every case. Veterinarians and behaviorists are the ones that can speak to that. Though I will tell you, veterinarians can have difficulty this in the legal arena, because the first question a client asks us in the exam room when we talk about what's going on is, are they suffering? And it's hard for the veterinarians to transition from answering suffering in that context where I have a relationship, I'm going to treat, or I'm going to mitigate that suffering, and then you put them on the witness stand that they're already afraid of being there anyways, and then someone asks them about suffering and they will hesitate right? So you have to work with the veterinarians and looking at it in a legal context as a snapshot window. That's a whole nother lecture. So with the emotional suffering of animals, how do we assess that? And there's some things we look for, also the absence of things, right? Do we see negative emotional states or the absence of joy, the absence of positive states? Because animals naturally seek that, no matter the species, the fish, right? So when we don't see this, or we see frustration, depression, anger, behavioral clues, including lack of responses, this complete shutdown that we can see, especially in our large-scale cases where they're not even doing things. How about failure to groom? Not maintaining their own body is a symptom that we've got a problem, right? So think about boredom, physical pain, isolation, living in violent environments, other animals' distress around them. When things are happening to them, another animal, does that impact the other animals around them? Yeah, right? Unsanitary environments, lack of food or water, that frustration they get. How about abandonment? What's the emotional suffering when an animal's been abandoned, confined, right? So how we make the case? These aren't bad, but they told me I had to give you a warning, that's just saying. This was a case out of Pennsylvania. This involved Holly Crawford, who was a groomer. She was piercing the ears of all these black kittens with 14-gauge earrings, the back of the neck with submission rings, the base of the tail. She would tie a rubber band around the base of the tail until it fell off. And then she would advertise them on eBay as gothic kittens. So there was an undercover investigator went out there, so they got to witness the kittens out there, and so they got evidence and then brought it to the authorities. The statute that they were going to apply was torture of animals. How can we apply that? That was the question. Can it be applied? Because they didn't die. They had some of the kittens that hadn't been sold, right? So how do you make the case for torture? And this comes up for a lot of laws around the United States and elsewhere. There's different ways to make it, and sometimes if it's not provided for in the law, like in Texas, it's really not as, I think it's unjustifiable pain or suffering, help me out, David, in my own state, but prolonged. Anytime an animal cannot escape or make a positive affect or a positive change on a negative environment. But there's been laws that have these languages in it: inability to escape, inability to meet the needs for a prolonged period of time. Doesn't say what's that in the experience. Is it 5 minutes? Is it 10 minutes? Is it 15 minutes? Is it days? Is it years? It's about that individual animal's experience and how you make that and who's going to articulate that on the stand, right? May require intent. Some of them require intent. Can we do that? Reasonable person standard. But what about starving an animal to death? Right? That's my big one. That's my, just so you know, I'll come out on video. That is a big pet peeve of mine. There is more suffering with an animal starving than there is from shooting them. Okay. So how do we make this? With this case, well, the kittens had infections at the piercing sites. They had the reduced ability to hear because of those ears being bent down. That's also how they communicate. They communicate with their tail. They balance with their tail. Turns out in kittens that the back of the neck is highly innervated, highly sensitive, because they're supposed to freeze and not do anything when mom picks them up, right? And then that sensitivity goes down, still there, but goes down as they become adults. Then there was the abnormal behavior. Normal kitten is running around with that tail straight up in the air and running until they pass out, right? The battery dies and they pass out and they get up and they do it again. These kittens were sitting, what I call meatloaf style, hunched up, not running around like the Ever-Ready battery commercial. So that's what I spoke to. And then they would try to rip the earrings out, and she would, when they did, pierce them again, right? So they couldn't get around. Is that torture? Yeah, well, that's what I said. And that it was a constant state of fear, pain, and all the impact. So she was found guilty. Now this was in Pennsylvania. This was before their laws improved, and I don't know where they are on the rankings. But she was sentenced, even with this criminal background, she was sentenced to 6 months house arrest, 21 months probation, psych eval, monitoring, and no contact with animals for that. But her history was what was bothersome to me with these 17 arrests, drug, robbery, and theft. So that's how that went. Then we have in Canada, in British Columbia with Desmond Haig. Now, Desmond Haig's an American. He is married. He's a CEO of this big major food distribution company that foods for like convention centers or football stadiums and so forth. But he's got a mistress in Vancouver who has a puppy and a little Doberman. And he's seen on this video abusing the dog. The BCSPCA, they called me, they didn't get notified for 2 or 3 days. So the ability to find what we need to look for on the veterinarian side 3 days later is not high, whether it's bruising or a muscle enzyme going up. So they looked, no exam, exam was unremarkable, but they've got Rebecca Ledger, who is a behaviorist and is doing a lot of forensic behavior analysis for these cases. So here's the video. Okay. Click again. Yeah. Okay. And you watch the dog's video or the behavior right away. See how it's moving away? It's not coming up to him. Lays down right away, and there's no audio. But right now, kick again. Dogs kick again, dog's doing nothing, just kind of gauging where he's at. And he gets down in his face. So prompting, terrorizing, yank again, actually lifts the dog, suspends him in the air. So on this one, okay. So the behaviors documents the distress the animals experience. We don't need audio, we don't need anything. There's no physical injury to this dog that's been documented. Past, could have been on those first days, right? But after the 3 days. He was found guilty. It was that first conviction just on emotional distress that they had, we believe, in North America at the time. 3 years, but Canada felt he had suffered enough in the court of public opinion. He still had his job, but he eventually resigned, and then he got the $5,000 fine. We had this case in DC. You're going to see a theme here with elevator videos. This involved Lulu. She was an older dog, been owned by this man and his partner her whole life. She has arthritis, medical issues. She's an old little fox terrier, Jack Russell Terrier. So there's videos capturing him being abusive in the lobby of the apartment, condo complex. And the security person who's sitting right there witnesses that and sees things on the elevator as well, and he reports it. The statute is knowingly tortures, torments, or cruelly beats, right? On the medical findings, also her history was high blood pressure, arthritis in her legs. She had a collapsed disc spaces, which means any kind of trauma like that could paralyze her. And then post-seizure, her exam, she had the hind limb stiffness, still the arthritis. So she had the chronic arthritis. She also had an acute injury in a shoulder that improved while at the shelter, meaning that it was related to this event. All right, so here we go. So he's been outside walking, and he comes in, there's another guy. This is Lulu right here. The dog comes up her butt. She turns around and, now watch, he hits her, throws her down, hits her again. And this is all because this dog came and got a little fresh, right? So she turned around and went, nah, nah, nah. There was no injury to that dog. This is the other view. See the guy's sitting here. They're gonna come in here, right, she's right. So they've already done the skirmish. She hits again. Yep. She hit her head there in that view, you can see. So what happens here, right, is like he's still talking. This dog's like, I'm staying away from him, right? Now watch this guy. He throws her down again. He's trying to comfort her. It's not his partner. It's some guy. He's trying to comfort her. So these dogs have not got along. Now they're keeping their distance, but what do? Hey, come on in. Let's all get on the elevator together, right? Let's put it in again. Yeah, it's running. There we go. Now watch her behavior. She's submissive, away from him. No, she's away from him, right? He yanks her, shoves her back. She's 14, almost 14 years old, right? The other dog's staying where? Away. Here at the front, I'm getting off first. And she's frozen, cowering, right? We got emotional suffering. That's not enough. So she starts moving up, slinking. Look at that behavior. Now watch what he does. Kicks her. Like she can't do anything right? Tail tucked, all this submission behavior. And it's those retractable leases. So watch, I don't know if you're gonna be able to see it, right? Here, yeah, I got it in the reflection, he kicks her again, right? What I said and what I was trying to apply in the report was that she suffered from prolonged extreme fear and pain, unable to escape the prolonged torment, which is torture. He showed extreme indifference to not only her life, but the risk of paralysis, all of that. And he knew she's an old arthritic, walking dog. So he took a plea. He didn't have anything in his history. He had to forfeit the dog, and he gave $500 to some DC Victims Fund. I think it's for the animals, but Lulu got adopted. That's the big thing on that. But just using video. Here in Nova Scotia, or not here in Nova Scotia, there was a case just recently where they had involving this Adam and his dog Sophie, and that he was caught on lobby video beating the dog with the leash. He's charged, the dog is seized by the Nova Scotia SPCA, and again, I think it was Rebecca Ledger that came in from BC and talked about that she suffered undue anxiety and suffering psychological harm and would continue to suffer if left in his custody. So they used that for their seizure hearing, right? And yeah, I guess I missed it the first time. I guess when he first walks in, the dog is walking and he spills his drink and he gets mad. There it spilled. Okay, yep. Now watch, look at the dog. It's just a leash. There's no audio. Trying to go out that door now. So he pled guilty after they got the behaviorist report. No animal ownership for 3 years, which is big for Canada, $1,000 fine, and she was adopted. I have to put that in, right? And then, like I said, consider suffering in those other types of cases, massive neglect. It's not just the ones that are sick, it's everybody's suffering, right? There's some kind of suffering going on. The animal fighting, when they're tethered, domestic violence cases, horrendous psychological, not knowing where it's gonna come from next, what's going on, right? And that's it for me with my wagon dog. All right, Randall. There you go.
Well, thank you all so much, and I think all of those stories that, they're very difficult to hear, but they do demonstrate how the law is treating animals as more than property, that not only recognizing physical pain, but also emotional suffering as well. So that's at least significant progress. If anybody has any questions, please come up to the mic. We'd be happy, our panelists would be happy to answer those now. Oh yes, please go ahead.
Hi, I'm Bailey Frank. I'm a first-year law student at Duke, and I wanted to thank you really so much for this talk. All of your talks were amazing, and I think especially coming up the last one, this question is really important for me. You talked a lot about targeting education, so educating judges, really important. Educating police officers, really important. Witnesses. But in the realm of 1L Law School, the curriculum is really standardized. And I have 200 students who have all publicly laughed at me when I said that I wanted to do animal law, because that's just the initial reaction. But coming off that presentation, I think that that's just a really powerful image, is 200 law students who are there under an ethics code, who want to, quote unquote, do law to change the world, laughing at that idea. So my question is, having worked in education and working with lawyers, both for the law students and the professors who have been just as dismissive, not to insult them. My professors are wonderful, but anytime I've asked questions, it's been a little dismissive. What are things I can do as a law student, or that we can do kind of as a movement or an organization to target that area in addition to animal law classes? Because I think since the 1L curriculum is so standardized, everyone's getting exposed to all of these different areas of the law. How can we kind of put animal law in there for education for educators and for law students?
Start. First, thank you for being here. Being here and networking with all of the tremendous talent and folks who are here is really one way to engage with other people. Being that voice in your law school can have a tremendous impact. Your legal career starts in law school. Those will be folks who you will interact with in a number of ways as you grow into being an attorney. So again, coming to things like this, connecting with people here and continuing those conversations, knowing that you're not alone, even though it might feel like it at times, is really important. I know that there are a number of educational opportunities through the Center for Animal Law Studies, through the Animal Legal Defense Fund, that are remote in terms of webinars, online courses. So please feel free to talk to me or others from ALDF after this talk, but at least from my perspective, know that you're not alone, and this is a great starting point, just being here.
I would say that you're doing great. Keep going. This is hard for me to say as a native Virginian, but Duke is a great law school. And
I almost went TV.
And when you get that education, you can do with it what you will. Like, I don't know that I would have told you in a million years that I'd be sitting on this stage when I was in law school. The main thing that got me here was not the classes that I took in law school, because they were not geared towards animals, and I was not particularly great at them, but the work that I did. I did an externship and an internship at a district attorney's office, which turned into a job at a district attorney's office, which turned into a job doing animal cruelty throughout the state. So really more important than the classroom time and what your professors think, which both Lora and I have worked as professors, and we don't know any more, I think, than the average law person. I would say definitely.
Thanks, Jake.
Follow your passion and get involved in the Student Animal Legal Defense Fund, which I assume has a branch there at Duke, and coming out to these things is great. And so keep going is what I'd say.
And I should add, and I should have mentioned earlier, again, a plug for ALDF.org, but go on our website because there are a number of clerkship opportunities, internships, externships.
Oh, I know.
At our organization and others, and those are, again, tremendous opportunities for getting plugged into this work.
Let's try to go rotate back and forth.
Hi there, I'm Kim Connolly from Buffalo, and I run the animal law clinic there. This was very, very informative. I know we don't have time, I don't want to take away the time, but I want to bring up one of the things I try and do in the clinic is take things that are smaller so that students can take the lead and get it done in a semester. And so that means that I do a lot of local work, which means that I end up, and I try and do not just in right where Buffalo is, but out in other counties in Western New York, which means I end up with having students work with really outmoded laws that have criminal components, really bizarre animal control officers who have a lot of political support. And so kind of thinking about how we can create together places where we can do better animal work and really understand how the criminal aspects come into it on a local level is something that I would be interested in talking with you about later and kind of bringing up here, because that's kind of where a lot of things get stuck and animals suffer and other people just are in a space that they have so much control.
Yeah, absolutely. And all of our panelists I know would be happy to discuss those things with you. Their emails were up on the screen. And I think we have just time for one more question, if we can sneak that in really quickly.
Thank you. My question's for Mr. Kamins. So, as you may be aware, the overwhelming majority of animal cruelty that occurs in this state is not to companion animals, but occurs on an industrialized, institutionalized level at factory farms. And I know the same legislature that recognized the sentience and value of animals also wrote in exceptions for farmed animals under so-called good husbandry practices, but there's an exception to that exception for gross negligence, and I'm hoping if you've ever visited a factory farm or seen some footage, the negligence of those practices is hopefully pretty apparent. So I'm wondering if your office has an awareness of that and has the compassion and ambition to look at cruelty very broadly in the state and not just for companion animals.
Sure. Thank you for your question. Thank you for coming. Yeah. I appreciate that question, and my purview is limited by the nature of my position. I am not a State Department of Justice Assistant Attorney General who would have statutory authority to go into a county and start a prosecution myself. I have to essentially be invited in by the local district attorney. So, and for that to happen, they have to get a referral for a case from law enforcement or animal control first. So, I appreciate the passion of activists and advocates for animals. I've certainly seen very disturbing videos in this regard. When it comes to referrals on industrial and factory size farming, I have not seen them yet. I would treat them as I treat any other referral that came across my desk. I would analyze it for violations of the law. I would take a look at the relevant legal statutes and requirements. The concept of gross negligence is, I don't know if you're familiar, not one that has been tested in that context a lot in the case law. So it could potentially be a case of first impression or a case where we're sort of making the law or clarifying the law as we go along. But I don't turn down cases on the basis of where they come from, the agency they come from, the situation they come from. I've done, single dog in a house cases, and I've done 200 head of cattle on a farm cases. So that's not a consideration that I put to it, but I do only handle the cases that come to me. I don't go out looking for cases aside from occasionally if I see something in the news, I may let the local district attorney know that my resource is available. But other than that, I'm not on the ground investigating. That would be an interesting thing to talk to legislators about, talk to stakeholders and policymakers about in terms of, are these the correct standards? But as my position is dependent on me being a prosecutor first, I have to apply the legal standards and deal with the cases as they come to me, as opposed to going out and trying to make cases happen. Thank you so much.
Thank you, everyone. I'm so sorry we don't have time for everyone's questions, but I know our panelists would be more than happy to discuss them with you if you want to come up and find them. Right now, we do have to break for lunch, so please join me one more time thanking our esteemed panelists.